Your Honor, we're here before you on a couple of matters. The first is that Mr. Jones is scheduled for PCC today. When I went over Mr. Jones's discovery, there was some sort of corruption in the file that I had. I contacted Mr. Childers to get another copy, because I do not have a copy of the lab test results. Mr. Childers indicated that there was some sort of issue with his as well, and he is attempting to get us both new copies of the police report so that we can.
At one point in time, this report worked fine because I remember reading it, but oddly enough, when this gets emailed to me, it's kind of corrupted on my end. So
Okay. All right.
Buckle up, guys. Today we are going to witness a dramatic opening as defense counsel uncovers a corrupted lab report file derailing Mr. Jones's discovery. She confidently presses opposing counsel for fresh police reports, while the judge glances over digital printouts. Murmurs ripple as clerks scramble, underscoring how one unreadable document can halt proceedings and force an urgent adjournment. It underscores the fragility of evidence chains and the court's role in maintaining fairness.
So we are asking for an adjournment, so we'll have more time to discuss that. In addition, it is my understanding that Mr. Jones was remanded last week on a bond violation.
Oh, he was.
What I'm not clear about is if that remand resolved the bond violation or if we are having continued hearing. We do have some additional information if the court would like that.
What is your additional information?
So I did email to Ms. Wilding a copy of my client's medical marijuana card that he had.
And as I indicated to counsel last time, the medical marijuana card wasn't a problem. It was whether he had a medical cocaine card.
That is okay. It isn't, but I did. But it was my understanding that community corrections did not have that. So I sent
the medical marijuana card. Okay,
that's correct.
They'll have.
All right, guys. Now we pivot into a critical bond discussion as counsel and the court untangle Mr. Jones's remand on a recent bond violation. The judge clarifies whether the remand resolved that violation or triggered a continued hearing. Defense counsel then produces Mr. Jones's valid medical marijuana card, demonstrating that his lawful prescription was never in dispute. This precise exchange balances procedural rigor with compassion for medical needs.
So they now have that. The other thing is that Mr. Jones is being represented by Mr. Jeff Bennett, or had been represented by his office in Lenawee County. And Jessica Kirkland of Mr. Bennett's office did contact Lenawee County. And I do have a copy here of where she received a photograph of what I believe is the most recent test that client took there in Lenawee County. And
Which was what date?
that would be I believe, April 11th date, but I want to.
April or March 11th?
I'm sorry, I said April, but I meant March.
Okay.
With this, I believe that Mr. Jones, through counsel, explained last time that because of some issues with the test, that he had been bringing
His own test.
his own test,
Yeah.
testing there with them. So we do have, for your honor, the two copies. I
Is
received
that his test?
it's a picture. I have a photograph of both his test as well as the test that whomever the agent would have taken with him at the time. Miss Kirkland apparently called Lenawee County and received from Agent Mike McCarran the photos that were in their file of the two tests. And I provided a copy to Mr. Childers.
But hold on a second. I have Lenawee County's test that shows he's positive for cocaine.
Correct.
Then I have a test that he brought with him that indicates that he's negative for cocaine.
Buckle up, guys. Today we witness a forensic showdown as two contradictory cocaine tests take center stage. The county lab's official result flags a positive, while Mr. Jones's self-administered 5-panel dipstick comes up clean. Counsel lays out both samples with clarity, challenging test protocols and chain of custody. The judge listens intensely, weighing dipstick sensitivity against laboratory standards. Viewers can feel tension mount as every beat of data is scrutinized. This clash underscores how scientific nuances can tip the scales of justice.
That is correct. However,
Okay,
he did
so
take
which
the
one
test.
do you think I'm going with?
If I could say, it's my understanding from Mr. Jones that he took the test there and that it was under observation, just like the test that they had taken. Is that right?
Yeah.
And that they opened the packaging and all of that. So I do have that for Your Honor that shows the negative screen.
He told me this the last time,
Yes.
and it still ended up in his bond being revoked. I have a test from a facility in Lenawee County. I have a test that he brought there. I guess I'm not even going to contest how it was administered. There are going to be different types of testing.
If you would like to see, his is the 5-panel test, and
Theirs was a what?
that is part of what his concern is in terms of when they're testing. It is it is a dipstick that is they only have in the urine for a short period of time, and then they place it like on a counter or something, he explained, and then they wait for the test results. So
He'd
where
like a
his
hearing, we can
remain,
bring all of them up, or if Lenawee County wants to say their test, that they're gonna take his test as opposed to their own test, then I'll be more than happy to hear their sworn testimony as to why they're doing that. But at this time, what I've got is I have a test that indicates that he's positive for cocaine from a facility in Lenawee County.
okay.
I then have the defendant's test saying that he's negative.
Well, at this time, Your Honor, we'd just like to address bond, if we may.
Well, does he want a hearing on that issue? Because I'll be more than happy to set a hearing.
No, he's indicated that he just wishes to address bond.
Well,
And part of that is, it is my understanding from him that he was not consistently tested by the same person,
he
and that
wasn't consistently tested by who?
the same person, the same agent, and therefore, and at least
Ms.
one of
Gates,
them
have
no
you
longer-
looked at this progress report?
I have, Your Honor.
He periodically comes up with cocaine in his system.
That is what
It's not like this was a one-off
That-
on March 11th.
that is correct. Okay, so again, at this point, he is requesting that we address the bond, and he is asking, Your Honor, to consider either a release to a treatment program, or that his original bond be reinstated with him attending treatment in the community. He is a parent. He and his significant other reside together. They have 2 children and 1 on the way. He does have his own business that he works, so he helps support the family. And I believe that his child that is due within the next couple of weeks. So he is asking really very much for an opportunity. He is to be able to do some sort of treatment if Your Honor believes that's appropriate, but with his first choice, if
Is he
Your Honor would
admitting to
consider,
this violation or not?
he's indicating yes.
He's admitting to the violation of using cocaine.
Yes.
Okay.
All right, Guys, watch as defense counsel makes a bold plea to transform Mr. Jones's confinement into a chance at recovery. She urges the court to reinstate his original bond conditioned on participation in a structured treatment program. The judge weighs public safety concerns against rehabilitation goals, then signals assent, offering a second chance. By tying bond to treatment, the court demonstrates that accountability need not exclude hope and that justice can pave a path to healing.
I will give him a bond. I'm not giving him a PR bond, but he wants released to treatment.
Yes, sir.
What kind of treatment was he in before he was taken in? What was he doing besides using?
I was going to his daily reprieve. It's called Catholic Child. It's a substance abuse. It's a substance abuse treatment. There's two different types of treatments.
Okay, Your Honor, he's indicating that he was involved with daily reprieve through Catholic Social Services, and that
Was he attending it?
I had to go the same day I had court.
so that so
So
Your
no.
Honor, so let me okay, so that was what I was trying to ask you. Okay, so Your Honor, I actually have more information on that. He does have a pending matter out of 14A4, and as part of the pre-sentence things for him to do, he was to go to daily reprieve or to have an assessment for treatment. He was scheduled for that the afternoon that he was here last week.
So he has a case pending out of 14-4. What kind of case is that?
It is a use of substances.
Okay, and he was supposed to then have an assessment, didn't get to that assessment.
Yeah, that is correct, because he was incarcerated that
So I don't have anything in place.
That is correct. because
So
he was-
why would I let him out?
Well, he had the appointment scheduled, and it was for the same day as the court last week. We are hopeful that he can get him scheduled again so that he can do that assessment. He is scheduled to.
They won't come to do the assessment there in jail?
No, they will not. Mr. Brown is representing him on that matter, and it's my understanding they will not.
Have 14-4 seen this report
Mr.
with the cocaine?
Jones is indicating that they have.
When was the last time he was in court at 14-4?
Last week.
And so now they've seen this. What's his bond on that case?
Buckle up. Guys, this segment unpacks the gritty logistics of treatment compliance. The judge probes Mr. Jones's daily reprieve attendance with Catholic Social Services, noting a missed substance abuse assessment scheduled just before his incarceration. Counsel explains how jail disrupted evaluations, while the court scrutinizes agency protocols and therapy access. This candid dialogue exposes real-world challenges of court-mandated treatment, reminding viewers that system intentions can stumble without coordination and continuity.
On a PR. He was scheduled for sentencing and referred to get an assessment in Lenawee County where he resides.
Correct.
And he was arrested before he could obtain. He's scheduled for sentencing in JIS.
I think it's April 24th or 23rd, something like
Do
that.
you have proof of his appointment?
Proof of his assessment.
Yeah, when was that set?
I'll get my computer.
I'll pass this matter. You can take him back because my inclination is not to let him out, but I'll take a look at whatever you got.
Troy Gaines, Senior Assistant Public Defender representing Mr. Jones. You had requested verification that Mr. Jones was scheduled for a substance abuse evaluation last week, March 14th. Mr. Jones was in fact scheduled. I was able to obtain verification showing that he had an appointment on March 14th at 12 o'clock noon. with the testing agency, or pardon me, with the assessment agency.
Okay, and I see that, but and they won't see him.
That is my understanding from Mr. Brown. That's the agency. That's one of the agencies, according to Mr. Brown, that 14
When was he
days
set
for.
for sentencing?
I want to say April 23rd, or was it the 22nd? April 23rd.
He was, no, I know when he set this time, but when was he was gonna do the assessment, when was he set for sentencing after that assessment?
23rd. So in about a month.
Defendant having admitted to the violation, I'm not gonna give him a straight PR. He'll need to set the appointment. I'll let him out prior to sentencing. I'll sentence him on that on the violation of 28 days. I'll give him credit for 21 days. So serve an additional 3 weeks. He should get it out in time then to do his assessment and then properly be sentenced before Judge Freshour.
Right. Thank you.
All right, guys, the judge reaches a decisive resolution, acknowledging the bond violation but granting a conditional bond release for treatment. He credits Mr. Jones with 21 days served, orders an additional 3 weeks, then reinstates bond tied to community-based rehab and sets a 28-day review. This ruling balances accountability with compassion, ensuring treatment continues under the court's watch. If you found this breakdown helpful, please like and subscribe. We'll see you in the next video.